Good morning, friends. Namaskar, Sasriyakal, and Adab. This is my 261st video, and in this video, I would like people to understand the various words in specific used in the Governor General Order. Now, this video is entirely for relating these words to the compensation. How we can make use of this for our compensation, because mostly we don't plead compensation when it comes to challenging the resumption notice. I have been requesting people that these two pleadings, whether we say we are not an old grant under GGO 179, we are not going to say that we are not an old grant. Yes, we are an old grant as per the general land register. Yes, we had the rights of holder of occupancy rights, but we are not a grant under GGO 179. Now, after this pleading, we can even simultaneously plead that what are my rights, even if the worst situation comes that I am being held as a grant and under GGO 179 or 260 or 238. Let's presume. So those words which are used in these GGOs, I am now going to define them under various laws so that we can plead simultaneously our rights to compensation. Now, after the GGO was made, there was a suffix, present market value. No compensation has been paid, or arbitration committee is ever constituted. Bungalow owners are left with no option but to die or leave their rights. Courts have been adjudicating and passing pro government orders without going into the constitutional rights of an Indian citizen given to him or her by the Constitution of India 1950. Now, what does the owner or the HOR want? Now, we have to take this courage to take the ministry head on. So, the courts will only then want to believe or would understand your plight. So, will the Constitution of India be at your mercy? Will that same Constitution of India be applied retrospectively? Is a very big question. So, whether these awards will be given to you after the constitutional duties of the Constitution. Now, whether I'm a grant, a special grant, or a past grant, or I'm a grant under GGO, let's forget all this. Let's come down to one simple logic. Why this discrimination? Even under a land acquisition act, if your land is being acquired, it is your right to be compensated. But here, unfortunately, there is a judgment, Harish Anand versus Union of India, or Union of India versus Harish Anand, because Mr. Anand died and it was an ex parte order, which clearly says compensation can flow in later. Let us first do one part of the resumption, which is under Regulation 6. So, what is the Ministry of Defense doing? It does not bring the truth forward. So the valuation for resumption is an ex parte, unilateral, and unrealistic doing. It is never to be understood because we don't plead through laws or rules. So these kind of things were allowed. No resumption policy or even the GGO as a complete is read in the courts. Now, Union of India very clearly, or with an arrogance, or with that mischief of being a Union of India's pleading, it breaks all the laws and then it walks scot free. So, what are we people? What are we HORs and old grant? What are we Indians? 1950 gave us the constitution. Are we really independent? Or did we achieve independence by living in these cantonments? So we are subjected to these atrocities by the hands of none other by the Ministry of Defense and the IDS officers sitting on chair. Is it to be said that way? No. I would put it this way, that when we don't know our rights, how can we blame somebody else? So we need to understand, what are we actually looking for? As tenants, or I really don't know what to say, but we have to wake up. The society is being deprived. There were about 669 cases of resumption after independence. How many have been compensated? How many of them have not been compensated? In my Ambala, we have about 52 bungalows which were resumed. Now, if you make a list, which I have, this may be similar, maybe less or more in all the 57 cantonments. So now I will read the definitions used in various laws, dictionaries, and judgments. Now, the first definition comes is compensation. According to the Oxford Dictionary, a suitable payment in return for loss, oblique damages, etc. Now, suitable would in this context mean market value or a replacement value. This has not happened in a single case. That is why, I say, please read the Governor General Order, either 179, 260, 238 in full with the court. Now, what does it read? Occupation of land and disposal of premises and buildings. And similarly, if you read the first regulation of 260, now in force in this presidency, is in regard to the occupation of ground and the disposal of premises or buildings within the limits of military cantonments are rescinded. Is this being read anywhere? What is the difference? There it was land, and here it is ground. So from land it is shifted to ground. Are these two different definitions, land and ground? Now building is being used in both our premises. Now, as per Cantonment Act 2006, definition in this act, unless there is anything repugnant to the subject or context, subject, subpara Act 24 of 1936, Section 2, for the original clause 4, building means a house, outhouse, stables, latrine, shed, hut, or other roofed structure, whether of masonry, bricks, wood, mud, metal, or other material, and any other part thereof, and includes a well and a wall. Now, the same definition as per the Municipal Taxation Act 1881 or 1902, Section 3, Subpara 2. Building means any shop, house, hut, outhouse, stable, a factory, an industrial shed, and a temporary structure erected by means of tenants and structures raised for entertainment purpose, whether roofed or not, and whether used for the purpose of human habitation or otherwise, and whether of masonry, bricks, wood, mud, thatch, metal, or any other material, whatever, and includes all well and walls. Section 37 has been widened by amending Act 1994 to include and shop, house, but outhouse, stable, a factory, an industrial shed, and a temporary structure, whether used for human habitation or otherwise. Now, where is this proven? It is proven in AIR 1925, Lahore 252. Wall is a building for the purpose of the act. Doors and windows also constitute building. The term would include erection, structure, and building, such as masonry walls, A compound wall comes within the definition of the term building. Rebuild of a wall from its foundation is equivalent to a building. Three-story building means building having their stories and not building having at least three stories. Cottage building of a wood would certainly be included as a building. So also would then barn and stables of a farm, though built only of wood and thatched with straw. But wherever the line defines building is to drawn, I am or the opinion that embankments must be outside it. Building is walled superstructure with a roof, but in some cases, building were with wooden roof structures with a roof has been held building. It is again proven in AIR 1927 Lahore 133. The word and every part thereof, as used in the definition of building, indicates that such a room in a building would be a building. AIR 1958 Patna 186. The props under certain beams of a house by themselves do not constitute a new construction. 1960 Jabalpur Law Journal 939. Now let's say there was the word building, now the other word is premises. Now again the Municipal Taxation Act 1881 or the 1902 section 11AA, premises means any land or building or part of a building and includes a the garden, ground, and outhouses, if any, pertaining to a building or part of a building. B, and fitting fixed to a building or part of building for more the more beneficial enjoyment therefore. So here the premises have been defined. Now the definition as per law lexion premises, from this use of the word premises, has gradually acquired the popular sense of land or building. Originally, it was only used in this sense by laymen, and it was never so used in will drawn instruments, but it is now frequently found in instruments and in acts of parliament as meaning land or house. Example: the Public Health Act 1875, Section 4, where premises includes massages, buildings, land, easements, tenements, and herdments of any tenure. Now, what does the Ballantine Journal Law Dictionary with Pronunciation second edition speaks? It defines premises applied to land. These two definitions clearly read that any premises or building, it includes land along with building. Now, will this make you clear that the Governor General Regulation GGO 179 under Regulation 7, it speaks house claimable for purchase or hire at option of owner, and Regulation 8 of GGO 260 of 1838 speaks that the occupant shall receive the full value of such house as a building, and in case of its being intended to keep up such house, it shall be at the option of the previous occupant to claim either it is full value as purchase or a fair rent for the occupation of the same. Now, the same definition of a house has been defined under Cantonment House Accommodation Act 1902 or 1923. It clearly says in Section 2, in this act, unless there is anything repugnant in the subject or context, F. House means a house suitable for occupation by a military officer or a military mess and includes the land and building apparent to a house. Is anything left? That if you read these GGOs correctly, it gives you the option of an owner in this. So the definition of the owner is very important here. The GGO is speaking of this. Read Cantonment Act 1889. Definition of owner includes the person who is receiving or entitled to receive the rent of any building or land, whether on his own account or on behalf of himself and others, or an agent or trustee, or who would so receive the rent or be entitled to receive it if the building or land were let to a tenant. You have the definition. You have the 1871 or the 1836 GGO. Let's go to Cantonment Act 2006. Again, what is it saying? It says in section 26 and under section ZL, owner includes any person who is receiving or is entitled to receive the rent of any building or land, whether on his own account or on behalf of himself and others, or on an agent or trust, or would so receive the rent to be entitled. So many places this definition of ownership is given. Now we are coming back to the Municipal Taxation Act 1881 or the Municipal Act 1902, Section 11. Owner means includes the person for the time being receiving the rent of land and building or either of them, whether on his own account or as agent or trustee for any person or society or for any religious or charitable purpose, or would who would receive the same if the land or building were let out to a tenant. These definitions are there. Now coming to Cantonment House Accommodation Act, what does 1902 or the 1923 definition section 2 subpara 1 says? Under section H, owner includes a person who is receiving or is entitled to receive the rent of a house, whether on his account or on behalf of himself and others, or as an agent or trust, or who would so receive the rent or be entitled to receive it if the house were let out to a tenant. And once again, these definitions prove that we were owners of our premises, house, land, along with building. Now, there's another word which is used in the GLR. Now, we've defined owners, we've defined premises, we've defined building, the word estate. Now, this definition also is very important. Now, what does state mean? Means the taluka or an immovable property acquired or held by a talukdar or grantee in the manner mentioned in section 345, or the immovable property conferred by a special grant of a British government upon the grantee. Now, where is all this written? One needs to understand. Now, these GGOs which I just mentioned, GGO 179 or 260, further, if you read Cantonment Land Administration Rules 1925 or 1937, Section 29, grants. To speak, it addresses we are owners as grantee. The definition of this word grant was defined in Act number 1 of 1869, passed by the Governor General of India in council for the Awadh state. Grantee means any person upon whom The proprietary rights in these estate has been conferred by a special grant of British government. So here we are. We have a definition of the word grant. Apart from that, we have many definitions of revenue free grants or Lakhe Raj grant. But to be a precise, the word grant is also defined. So whether these statutes on the definition of old grant or grantee were never produced in front of the honorable courts. So the courts would pass a judgment on what the Department of the Union of India is saying. So where are these statutes which are imbibed in the GGO when we are seeking for a pleading for compensation? What does the statute of interpretation quote? It says, wide a judgment AIR 2009 NOC 912 page, Bombay 2009 AIR, Supreme Court of India, Javed Sheikh Mustaq Patel versus State of Maharashtra. Interpretations of the provisions of statute cannot be foundation for interpretations of provisions in another statute unless provisions are in pari materia. Similarly, we have a judgment AIR 2006, Supreme Court 1489, Bombay Dine versus Bombay Environmental Action Group. Interpretation of statutes, external aids, words used in later and earlier statutes or in a statute before and after amendment to be given the same meaning. Now, the GGO has been defined. I have very clearly told you. So, again, when we go back to the CLA rules 1925-37, when we read section 9, subpara 4, subpara C, it reads in accordance with the terms of grant and speaks of market value. Section 7, subpara 3, subpara C again speaks of market value. These are all related to your compensation. So the definition in the Municipal Taxation Act 1881 or 1902, 8AA, market value means the market value of the land or the building which is determined in accordance with the principles contained in section 23 of the Land Acquisition Act 1894, or is determined in accordance with the provisions under the Registration Act 1908. Now, the same Act of Municipal Taxation in Section 21, market value means the price that a willing purchaser would pay to a willing seller for the purpose having due regards to its existing condition with all its existing advantage and its potential possibility when land out in the most advantageous manner, excluding any advantage due to the carrying out of the scheme for which the property is compulsorily acquired. In considering market value, the distinction of the vendor to the part which with his land and the urgent necessity of the purchaser to buy should be disregarded. There is an element of guesswork inherent in most cases involving determination of the market value of the acquired land. But the nature of things cannot be helped. The essential thing is to keep in view the relevant factors prescribed by the Act. If the judgment of the High Court reveals that it has taken into consideration the relevant factors, its assessment of the market value required land should not be disturbed. AIR 1976, Supreme Court 2219. Now, market value in another judgment of Supreme Court 2014 1 CCC 669, right to fair compensation stands till Union of India has neither deposited nor paid the compensation, and the plaintiff, or let's say me, is in litigation. No compensation paid means will have to pay under the new Rehabilitation Resettlement Act of 2013. We have everything in place if we go in for our this pleading. And believe me, I can bet the department will shake up. That judgment of Harish Anand, which they quote, will go bonkers. We can actually take our level to a different stage. Friends, again, I'm saying we are old grants, we were revenue free grants, never converted into new grants by the Britishers and either of the regulations till 1859. So our rights are proprietary rights. So we can ask for this compensation. Thank you. Good day.